Now, I want to skip down another paragraph, and we're now going to read about Justice Hugo Black's dissent in Griswold versus Connecticut. Black feared that using such a phrase as right to privacy could be a double-edged sword. One of the most effective ways of diluting or expanding a constitutionally guaranteed right is to substitute for the crucial word or words of a constitutional guarantee another word or words more or less flexible and more or less restricted in meaning. Privacy is a broad, abstract, and ambiguous concept which can easily be shrunken in meaning, but which can also, on the other hand, easily be interpreted as a constitutional ban against many things other than searches and seizures. I like my privacy as well as the next one, but I am nevertheless compelled to admit that government has a right to invade it unless prohibited by some specific constitutional provision. And that's what I've been telling you ever since we started reading this opinion. That unless you have the right to do a thing, you don't have the right to do it in private. You do not have the right to beat someone with a crowbar in public. Therefore, you don't have the right to do it in private. You have the right to speak freely in public. Therefore, you have the right to speak freely in private. You have the right to assemble together. I would assume that an assembly is public. Therefore, you have a right to assemble privately. If that makes sense. Clear as mud? Okay. Is there anything else that I want to read before we move on? I might just want to do that. Yes, I do. Now, penumbra is here from Griswold versus Connecticut. Notice this is a quote from the book again. This is Levin's words. Notice how the judicial activists work, inserting a word in a majority opinion here and there, inserting a phrase in a dissenting opinion, all the while biding their time until 5 justices can be convinced to join the case. I want to go ahead and read the next paragraph. The facts of Roe are straightforward. Roe could not legally obtain an abortion in Texas, where it was a crime to procure an abortion or to attempt to perform an abortion, except by medical advice for the purpose of saving the life of the mother. The central issue was whether Roe had a right to abort her baby, although her life was not at risk. Let's see. I'm going to skip ahead because they talk a lot about the next several paragraphs is about, quote, an opportunity to explore how external influences as well as a justice's personal foibles and prejudices can contribute to judicial activism. So I'm going to skip over that area there. And I'm going to get on to this paragraph. Other justices, that is, other than Blackmun, were also predisposed to dismantle the nation's abortion laws, including another Nixon appointee, Lewis Powell. As Bob Woodward noted, Powell came quickly to the conclusion that the Constitution did not provide meaningful guidance. The right to privacy was tenuous, at best it was implied. If there was no way to find an answer in the Constitution, Powell felt he would just have to vote his gut. Skipping on down a few lines. He made a policy decision and then set out to justify it. That is textbook judicial activism. Now, a little bit more, more of these quotes that I want to read to you come from Blackmun's opinion. So we're going to continue to read this opinion. It perhaps is not generally appreciated that the restrictive criminal abortion laws in effect in a majority of states today are of relatively recent vintage. Those laws, generally prescribing abortion or its attempt any time during pregnancy, except when necessary to preserve the pregnant woman's life, are not of ancient or even common law origin. Instead, they derive from statutory changes effected for the most part in the later half of the 19th century. Now, let's talk about common law. I'm going to look up the Wikipedia entry on English common law, and we're just going to see We're going to read a little bit about this before we move on. Common law is a term with historical origins in the legal system of England. It denotes the judge-made law that developed from the early Middle Ages as described in a work published at the end of the 19th century, in which these two guys expanded on the work of Coke and Blackstone. Specifically, the law developed in England's Court of Common Pleas and other common law courts, which became also the law of the colonies settled initially under the Crown of England. Common in the Oxford English Dictionary, common law is described as the unwritten law of England, administered by the King's Courts, which purports to be derived from ancient usage and is embodied in the older commentaries and the reports of abridged cases. So this is what English common law is, in short. So you might be able to understand just by reading this why English common law wouldn't say anything about an abortion, because it would be so rare and so rarely practiced safely that it would rarely come before the courts that a woman had committed an abortion, now we want to know what to do with her. Or a doctor has successfully performed an abortion and the woman survived, we want to know what to do with him. It would probably come up as an abortion was committed and a woman died. What do we do with the guy that performed the abortion? The person that performed the abortion? Because it would be extremely dangerous to perform the abortion. Or a baby was killed in the womb against the mother's will. What do we do with the killer? Would be the way that these laws, I think, that's just me thinking here, just a stupid redneck thinking here, about how abortion would have been addressed in English common law. That's why it's not ancient. And the reason why the laws that Blackman is now writing about are new is, again, we're in the 1970s. We're in the midst of the sexual revolution. So people are wanting to have more unprotected sex and not deal with the consequences. One of the consequences of unprotected sex is pregnancy. So when people get pregnant and they want to continue to be able to live their promiscuous lifestyle, what do they want to do? They want to terminate the abortion. And as has been said in other places, states are, well, maybe it's a quote out of this book, actually. I think it was one of the judges in the Roe v. Wade case that said that states are too slow yes. Justice Potter Stewart was in favor of striking down abortion laws. Stewart thought abortion reform was necessary for various policy reasons. As Stewart saw it, abortion was becoming one reasonable solution to population control. These issues were of the sort that made Stewart uncomfortable. State legislatures were always so far behind, few seemed likely to amend their abortion laws. Much as Stewart disliked the courts being involved in this kind of controversy, this was perhaps an instance where it had to be involved. So states are behind the curve, you might say, as far as cultural tides go. So when people are getting abortions, states are looking at that and saying, whoa now, we don't like this, we're going to ban it. So up to the sexual revolution, people weren't getting a lot of abortions. It wasn't very widespread. That's why these laws are quote-unquote new, as Blackman is calling them. And look at this. Look at all of this. None of this, if I understand this opinion correctly, none of this is legal analysis. This is all historical analysis. Paragraph 1, ancient attitudes. These are not capable of precise determination. We are told that at the time of the Persian Empire, abortifacients were known and that criminal abortions were severely punished. We're also told that abortion was practiced in Greek times and in the Roman era, and that it was resorted to without scruple. The Ephesians, Soranus, Soranos, often described as the greatest of the ancient gynecologists, appears to have been generally opposed to Rome's prevailing free abortion practices, he found it necessary to think first of the life of the mother, and he resorted to abortion when, upon this standard, he felt the procedure advisable. Greek and Roman law afforded little protection to the unborn. If abortion was prosecuted in some places, it seems to have been based on a concept of a violation of the father's right to his offspring. Ancient religion did not bar abortion. Bull. First of all, America is based on Judeo-Christianity. I'm sorry if you're a Muslim and you disagree, that's the facts. America's laws are based on English common law and Judeo-Christianity. Where Judeo-Christianity and Muslim law and Muslim tradition overlap, that's where it's based on Muslim tradition. But it's not like the founders said, let's get out the Quran and see what laws we should pass upon our society. So we're not based on Greek and Roman law. We're based on English common law and Judeo-Christianity. We're not based on Greek and Roman tradition. We're not based on Persian tradition. The Hippocratic Oath. What then of the famous oath that has stood so long as the ethical guide of the medical profession, and that bears the name of the ancient Greek, who has been described as the father of medicine, the wisest and greatest practitioner of his art, and the most important and most complete medical personality of antiquity, who dominated the medical schools of his time and who typified the sum of medical knowledge of the past. The oath varies somewhat according to the particular translation, but in any translation the content is clear. I will give no deadly medicine to anyone if asked, nor suggest any such counsel, and in like manner I will not give to a woman a pessary to perform an abortion. Or, I will neither give a deadly drug to anybody if asked for it, nor will I make a suggestion to this effect. Similarly, I will not give to a woman an abortive remedy. Although the oath is not mentioned in any of the principal briefs in this case or in Doe v. Bolton, it represents the apex of the development of strict ethical concepts in medicine, and its influence endures to this day. Why did not the authority of Hippocrates dissuade abortion practice in his time or in that of Rome? The late Dr. Edelson provides us with a theory. The oath was not uncontested even in Hippocrates' day. Only the Pythagorean school of philosophers frowned upon the related act of suicide. Most Greek thinkers, on the other hand, commended abortion, at least prior to viability. For the Pythagoreans, however, it was a matter of dogma. For them, the embryo was animate, and from the moment of conception, an abortion meant destruction of a living being. The abortion clause of the oath, therefore, echoes Pythagorean doctrines. In no other stratum of Greek opinion were such views held or proposed in the same spirit of uncompromising austerity. So, what are you trying to say, Blackman? Are you saying that because Hippocrates was in the minority, that the Hippocratic Oath is meaningless? What's the meaning of this paragraph, besides you throwing words at us and hoping they stick? Dr. Edelson then concludes that the oath originated in a group representing only a small segment of Greek opinion, and that it certainly was not accepted by all ancient physicians. He points out that medical writings down to Galen gave evidence of the violation of almost every one of its injunctions, but with the end of antiquity, a decided change took place. Resistance against suicide and against abortion became common. The oath came to be popular. The emerging teachings of Christianity were in agreement with the Pythagorean ethic. The oath became the nucleus of all medical ethics and was applauded as the embodiment of truth. Thus, suggests Dr. Edelson, it is a Pythagorean manifesto and not the expression of an absolute standard of medical conduct. So because it's not an absolute standard of medical conduct, we can just kill babies. Is that what you're saying, Blackman? I don't like it. I don't agree. Not in the slightest. You know, think about this. You know, if you want to use the word, the Pythagoreans and Hippocrates were very progressive in conferring greater responsibility upon doctors to practice carefully to their patients. You could have doctors that don't take this oath and give deadly advice and kill their patients, and that would be very unprogressive. That would be very backwards medical practice. Let us read on. This, it seems to us, is a satisfactory and acceptable explanation of the Hippocratic Oath's apparent rigidity. It enables us to understand in historical context a long accepted and reserved statement of medical ethics. So that makes me think, that paragraph there, makes me think that the reason Blackmun included all of this about the oath is so that he could shake your confidence in the oath as a good thing. Let's move on. The common law. It is undisputed that at common law, abortion performed before quickening, the first recognizable movement of the fetus in utero, appearing usually from the 16th to 18th week of pregnancy, was not an indictable offense. The absence of a common law crime for pre-quickening abortion appears to have developed from a confluence of earlier philosophical, theological, and civil and canon law concepts of when life begins. These disciplines variously approach the question in terms of the point at which the embryo or fetus became formed or recognizably human, or in terms of when a person came into being, that is, infused with a soul or animated. A loose consensus evolved in the early English law that these events occurred at some point between conception and live birth. Okay, Blackmun. When the fetus became recognizably human, English common law said it's wrong to kill it. If you're watching this with children, or if you have weak constitutions, you might want to turn away. I am reminding myself now to put a timestamp in the description of this video of when you should come back and watch again, because we're going to do a Google image search for fetus in the womb. And we're getting artistic representations so far. At 1 month, it looks like this. At 2 months, I don't know about you guys, that looks pretty human to me. I mean, yeah, it looks sort of alien in its appearance. But you can see a head, you can see eyes, you can see arms, you can see legs, you can see a belly. At 3 months, it just becomes more and more pronounced. I don't know. What do you guys think? Does this look sufficiently human to you? Does this look sufficiently human to you? We won't revisit that. A loose consensus evolved blah, blah, blah. This was mediate animation. Christian theology and the canon law came to fix the point of animation at 40 days for a male, 80 days for a female. That seems strange. I don't think that it says in the Bible anywhere that a male fetus is animated at 40 days and a female at 80. A view that persisted to the 19th century. There was otherwise little agreement about the precise time of formation or animation. There was agreement, however, that prior to this point, the fetus was to be regarded as part of the mother, and its destruction therefore was not homicide. Due to continued uncertainty about the precise time when animation occurred, to the lack of any empirical basis for the 40-80 day view, and perhaps to Aquinas's definition of movement as one of the two first principles of life, Bracton focused upon quickening as the critical point. The significance of quickening was echoed by later common law scholars and found its way into the received common law in this country. I have a question. Just because something is legal, does that make it right? Any liberals out there? Slavery was once legal in the United States. Does that make it right? Just because abortion was quote-unquote legal in English common law does not make it automatically right. Moving on. Whether abortion of a quick fetus was a felony at common law or even a lesser crime is still disputed. Bracton, writing in the 13th century, thought it homicide, but the later and predominant view following the great common law scholars has been that it was, at most, a lesser offense. In a frequently cited passage, Coke took the position that abortion of a woman quick with child is a great misprision and no murder. Blackstone followed, saying that while abortion after quickening had once been considered manslaughter, modern law took a less severe view. A recent review of common law precedents argues, however, that those precedents contradict Coke and that even post-quickening abortion was never established as common law crime. Again, we've talked about why I think that is. I think it's because abortions were probably not successful, where success is defined as killing the fetus but not the mother. You probably had a lot more abortions that ended in the death of both the fetus and the mother than you had abortions that ended in the death of just the fetus. You probably also had abortions that were committed against the will of the mother. So there's that to take into consideration as well. This is of some importance because while most American courts ruled in holding or in dictum that abortion of an unquickened fetus was not criminal under received common law, others followed Koch in stating that abortion of a quick fetus was misprison, a term they used to translate to mean misdemeanor, that their reliance on Koch on this aspect of the law was uncritical and apparently, in all the reported cases, dictum, due probably to the paucity of common law prosecutions for post-quickening abortion, makes it now appear doubtful that abortion was ever firmly established as a common law crime, even with respect to the destruction of a quick fetus. I've talked about why that is. English statutory law, England's first criminal abortion statute. We could keep going. Do I have to keep going? There is no legal analysis here. We're talking about the history of abortion. Let's move on to paragraph 6. The position of the American Medical Association. The anti-abortion mood prevalent in the country of the late 19th century was shared by the medical profession. Indeed, the attitude of the profession may have played a significant role in the enactment of stringent criminal abortion legislation during that period. The AMA Committee on Criminal Abortion was appointed in May of 1857. It's presented its report to the 12th annual meeting. That report observed that the committee had been appointed to investigate criminal abortion with a view to its general suppression. It deplored abortion and its frequency, and it listed 3 causes of this general demoralization. The first of these causes is widespread popular ignorance of the true character of the crime, a belief, even among mothers themselves, that the fetus is not alive till after the period of quickening. I'm going to end it there. It's been an hour, and we're going to come back next time. That the fetus is not alive until after the period of quickening. This indicates that the American Medical Association in May of 1857 believed that the fetus was alive before the period of quickening, because they say that it's ignorance to believe that the fetus is not alive till after the period of quickening. The second of the agents alluded to is the fact that the profession themselves are frequently supposed careless of fetal life. That sentence is strange to me. The second of the agents alluded to is the fact that the profession themselves are frequently supposed careless of fetal. That's a weird sentence. That doesn't seem even correct. The third reason of the frightful extent of this crime is found in the grave defects of our laws, both common and statute, as regards the independent and actual existence of the child before birth as a living being. These errors, which are sufficient in most instances to prevent conviction, are based and only based upon mistaken and exploded medical dogmas. With strange inconsistency, the law fully acknowledges the fetus is in utero and its inherent rights for civil purposes, while personally and as criminally affected, it fails to recognize it, and to its life as yet denies all protection. The committee then offered, as the association adopted, resolutions protesting against such unwarrantable destruction of human life, calling upon state legislatures to revise their abortion laws. This seems to drag on forever. This is still history. We've finally reached the end of the history analysis. After nearly an hour. Oh, man. Let's move on to the next section before I lose my mind. 3 reasons have been advanced to explain historically the enactment of criminal abortion laws in the 19th century and to justify their continued existence. So, are we getting to the legal analysis? Are we getting to the constitutional analysis yet? Victorian social concern. Nope, I don't think we are. Let's give the guy a chance, I guess. It has been argued occasionally that these laws were the product of a Victorian social concern to discourage illicit sexual conduct. Texas, however, does not advance this justification in the present case, and it appears that no court or commentator has taken the argument seriously. The appellants and amici contend, moreover, that this is not a proper state purpose at all and suggest that, if it were true, the Texas statutes are overbroad in protecting it, since the law fails to distinguish between married and unwed mothers. A second reason is concerned with abortion as a medical procedure. When most criminal abortion laws were first enacted, the procedure was a hazardous one for the woman. This was particularly true prior to the development of antisepsis. Antiseptic techniques, of course, were based on discoveries by Lister, Pasteur, and others first announced in 1867, but were not generally accepted and employed until about the turn of the century. Abortion mortality was high even after 1900 and perhaps as late as the development of antibiotics in 1940s. Standard modern techniques such as dilation and curettage were not nearly so safe as they are today. It has been argued that a state's real concern in enacting a criminal abortion law was to protect the pregnant women, that is, to restrain her from submitting to a procedure that placed her life in serious jeopardy. Modern medical techniques have altered this situation. The state has a legitimate interest in seeing to it that abortion, like any other medical procedure, is performed under circumstances that ensure maximum safety for the patient. This interest obviously extends at least to the performing physician and his staff, to the facilities involved, and to the availability of aftercare and to adequate provision for any complication or emergency that might arise. The prevalence of high mortality rates at illegal abortion mills strengthens rather than weakens the state's interest in regulating conditions under which abortions are performed. Moreover, the risk to the woman increases as her pregnancy continues. Thus, the state retains a definite interest in protecting the woman's own health and safety when an abortion is proposed at the late stage of a pregnancy. The third reason is the state's interest. Some phrase it in terms of duty in protecting prenatal life. Some of the argument for this justification rests on the theory that a new human life is present from the moment of conception. The state's interest and general obligation to protect life then extends, it is argued, to prenatal life. Only when the life of the pregnant mother herself is at stake, balanced against the life she carries within her, should the interest of the embryo or fetus not prevail. Logically, of course, a legitimate state interest in this area need not stand or fall on acceptance of the belief that life begins at conception or at some other point prior to live birth. In assessing the state's interest, recognition may be given to the less rigid claim that as long as at least potential life is involved, the state may assert interest beyond the protection of the pregnant woman alone. So this paragraph is where Blackmun begins to degrade, to demote, if you will, the unborn fetus from a living person inside the womb to a non-living clump of cells. But think about where he's taking us in the direction of where'd the word go? Potential life. Potentiality. If the life that's being killed could survive outside of the womb, then the state has an interest in preventing that life from being terminated. So what happens when we can raise babies or raise unborn babies in test tubes? Does that mean that we can ban abortion? I would think that the abortion hawks, the feminazis, would shriek and howl at that proposal. But that is the landing board on which Blackmun has rested. Potentiality of life. So let's move on. Parties challenging state abortion laws have sharply disputed in some courts the contention that a purpose of these laws when enacted was to protect prenatal life, pointing to the absence of legislative history to support the contention. They claim that most state laws were designed solely to protect the women. Because medical advances have lessened this concern, at least with respect to abortion and early pregnancy, they argue that with respect to such abortions, the laws can no longer be justified by any state interest. There is some scholarly support for this view of original purpose. The few state courts called upon to interpret their laws in the late 19th and 20th centuries did focus on the state's interest in protecting the woman's health rather than preserving the embryo and fetus. Proponents of this view point out that in many states, including Texas, by statute or judicial interpretation, the pregnant woman herself could not be prosecuted for self-abortion or for cooperating in an abortion performed upon her by another. They claim that adoption of the quickening distinction, though through received common law and state statutes, tacitly recognizes the greater health hazards inherent in late abortion and impliedly repudiates the theory that life begins at conception. It is with these interests and the weight to be attached to them that this case is concerned. Okay, so Blackmun decided that the parties challenging state abortion laws were correct. He decided, based upon interpretations of lower courts here, that there was absolutely no reason beyond the health of the woman that an abortion law was enacted. It couldn't possibly be that abortion was just not all that common up until the point that states began passing these anti-abortion laws. It couldn't be that people were not so sexually immature that they didn't just go sleeping around with whoever they wanted to, getting pregnant and then wanting an abortion. That could be, that couldn't be the case, according to Blackmun. It couldn't be the case that as abortion, the tendency to commit abortion began to rise, that lawmakers sought to curb this behavior for the sake of protecting the life of the infant. That couldn't possibly be the case. No. The laws are too young. Therefore, they must have been for the sake of, quote unquote, protecting the women because the abortions were too dangerous. And here is where the opinion should stop. The Constitution does not explicitly mention any right of privacy. In a line of decisions going back perhaps as far as Union Pacific Railroad Company versus Botsford, the court has recognized that a right of personal privacy or guarantee of certain areas or zones of privacy does exist under the Constitution. In varying contexts, the court or individual justices have indeed found at least the roots of that right in the First Amendment, in the Fourth and Fifth Amendment, in the penumbras of the Bill of Rights, in the Ninth Amendment, or in the concept of liberty guaranteed in the first section of the 14th Amendment. So, based on that paragraph, the suit brought by Roe seems home-cooked for Blackmun to call up all of these specters of previous decisions. You gotta love the linguistic weaseling that happens right here. That a right of personal privacy or a guarantee of certain areas or zones of privacy. See, I don't agree with this, but I do agree with this. See, why couldn't Blackmun just say that the court has recognized that certain areas or zones of privacy are guaranteed under the Constitution? Why did he lump in or a right of personal privacy? It's because he wants to expand the definitions. It's because he wants to expand the certain areas or zones of privacy. That's the only reason to use a more ambiguous term like right of personal privacy and then lump it in with the certain zones of privacy. These decisions make it clear that only personal... That was a strange way to pronounce decisions. These decisions make it clear that only personal rights that can be deemed fundamental or implicit in the concept of ordered liberty are included in this guarantee of personal privacy. They also make it clear that the right has some extension to activities relating to marriage, family relationships, and child rearing and education. The right of privacy, and again, these decisions were made by men. Men are fallible. Just because you wear a black robe and sit on the Supreme Court doesn't mean you're right all the time. We see that every single time a Supreme Court decision is overturned. The Supreme Court is saying, those guys made the wrong decision. It could be that the Supreme Court made a wrong decision in all of these cases. But Blackmun just assumes these guys wear black robes and sit on a bench, so they must have been right. This right of privacy, whether it be founded in the 14th Amendment's concept of personal liberty and restrictions upon state action as we feel it is, or as the District Court determined in the 9th Amendment's reservation of the rights of the people, is broad enough to encompass a woman's decision whether or not to terminate her life that's living within her. Let's quit saying terminate her pregnancy and start saying kill the life that is inside her. The detriment that the state would impose upon the pregnant woman by denying this choice altogether is apparent. Only if it's not a life. The detriment that the state would impose upon the pregnant woman is the inconvenience of not being able to kill what you consider a mistake. And I'm sorry, I find that an evil, evil notion. That you made a mistake, therefore you get to kill the life that is inside you. Specific and direct harm, medically diagnosable even in early pregnancy, may be involved. Maternity or additional offspring may force upon the woman a distressful life and future. Maybe you should have thought about that before you had sex! Maybe you should have thought about your situation before you decided to go and get pregnant, apparently, again. Psychological harm may be imminent. Whatever. Mental and physical health may be taxed by child care. Maybe you should have thought about that before you slept around. There is also the distress for all concerned associated with the unwanted child. I've got a solution. Adoption. There are people that can't have children that would kill to take your child that you don't want. That would kill to get pregnant. And you would like to kill your unwanted child. You would like to throw this child away as if it were trash because you don't want it. I'm sorry, but I don't think that that is grounds to overturn the right to life, Blackmun. And there's the problem of bringing a child into a family already unable psychologically and otherwise to care for it. How about we bring the child into the world and hand it over to a family that is able psychologically and otherwise to care for it? Because there are couples that want to have children, that would die to have children. This is kind of like the starving children in Africa argument. When your kid wants to throw away his vegetables, you say there are starving children in Africa that would kill you to take that food. There are barren couples in this world that would kill to take your child, that would die to have a family. And you want to throw your child in the trash. In other cases, as in this one, the additional difficulties and continuing stigma of unwed motherhood may be involved. I'm going to quote a meme here. The additional difficulties and continuing stigma of unwed motherhood may be involved. Boo! Hoo! Hoo! Maybe you should have thought about that before you went and had sex as a single woman. All these factors the woman and her responsible physician necessarily will consider in this consultation. No, I don't think that the doctor should look at your irresponsibility and say, gee, I guess you should get to abort your baby. I guess you should get to kill your baby. I think the doctor should look at your irresponsible decision and say, tough luck. I think the doctor should look at your irresponsible decision and say, deal. On the basis of elements such as these, appellant and some amici argue that the women's right is absolute. Okay, so the women's right to kill her baby is absolute and cannot be abridged by the child's right to life. How about maybe you should have thought about your liberty before you decided to become responsible for another life? That's what having sex is, boys and girls. And that she is entitled to terminate her pregnancy at whatever time. No, she is not. In whatever way, and for whatever reason. Holy cow. We're actually reading that feminazis were involved in arguing this case and convinced Blackmun to overturn the right to life. We're actually reading the words of feminazis in a Supreme Court opinion. With this, we do not agree. Appellant's arguments that Texas either has no valid interest at all in regulating the abortion decision or no interest strong enough to support any limitation upon the woman's sole determination are unpersuasive. Okay, maybe I overreacted. Maybe I reacted prematurely. I'm sorry, I got a little bit fired up. Immediately after that statement, Blackmun says that the court doesn't agree that the woman has the right to terminate her pregnancy at whatever time, in whatever way, for whatever reason. Moving on. That this was allowed to be said in a courtroom appalls me. The court's decisions recognizing a right of privacy also acknowledge that some regulation in areas protected by that right is appropriate. So the right to privacy is contextual. So why did you say that the right to privacy was general if it's contextual? As noted above, a state may properly assert important interests in safeguarding health, in maintaining medical standards, and in protecting potential life. At some point in pregnancy, these respective interests become sufficiently compelling to sustain a regulation of the factors that govern the abortion decision. The privacy right involved, therefore, cannot be said to be absolute. In fact, it is not clear to us that the claim asserted by some amici that one has an unlimited right to do with one's body as one pleases bears a close relationship to the right of privacy previously articulated in the court's decisions. The court has refused to recognize an unlimited right of this kind in the past. Good. We therefore conclude that the right of personal privacy includes the abortion decision. No. But that this right is not unqualified and must be considered against important state interests in regulation. Yeah, the right includes abortion, but it must be regulated because it doesn't include abortion. The right to free speech and assembly and other things, those are included in the right to privacy. You made up the right to privacy includes the abortion decision. We note that those federal and state courts that have recently considered abortion law challenges have reached the same conclusion. So because they're right, it must be right. A majority, in addition to the district court in the present case, have held state laws unconstitutional, at least in part, because of vagueness or because of overbreadth and abridgment of rights. Others have sustained state statutes. Crossan versus Attorney General, appeal docketed, blah, 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 blah. Although the results are divided, most of these courts have agreed that the right of privacy, however based, is broad enough to cover the abortion decision, that the right nonetheless is not absolute and is subjected to some limitations, and that at some point the state interests as to protection of health, medical standards, and prenatal life become dominant. We agree with this approach. Where certain fundamental rights are involved, the court has held that regulation limiting those rights may be justified only by a compelling state interest. How about the life of the unborn child? I think that might be a compelling state interest. And that legislative enactments must be narrowly drawn to express only the legitimate state interest at stake. In the recent abortion cases cited above, courts have recognized these principles. Those striking down laws have generally scrutinized the state's interest in protecting health and potential life, and have concluded that neither interest justified broad limitations on the reasons for which a physician and his pregnant patient might decide that she should have an abortion in the early stages of pregnancy. Courts sustaining state laws have held that the state's determinations to protect health or prenatal life are dominant and constitutionally justifiable. The district court held that the appealee failed to meet his burden of demonstrating that the Texas state's infringement upon Roe's rights was necessary to support a compelling state interest, and that, although the appealee presented several compelling justifications for state presence in the area of abortions, the statutes outstripped these justifications and swept far beyond any areas of compelling state interest. Appellant and appellee both contest that holding. Appellant, as has been indicated, claims an absolute right that bars any state imposition of criminal penalties in the area. Appealee argues that the state's determination to recognize and protect prenatal life from and after conception constitutes a compelling state interest. As noted above, we not fully agree with either formulation. The appealee and certain amici argue that the fetus is a person within the language and meaning of the 14th Amendment. In support of this, they outline at length and in detail the well-known facts of fetal development. If this suggestion of personhood is established, the appellant's case, of course, collapses, for the fetus's right to life would have been guaranteed specifically by the amendment. The appellant conceded as much on re-argument. On the other hand, the appealee conceded on re-argument that no case could be cited that holds that a fetus is a person within the meaning of the 14th Amendment. Yet this was your opportunity to do this. And Blackmun decided no. The Constitution does not define a person in so many words. Section 1 of the 14th Amendment contains 3 references to person. The first, in defining citizen, speaks of persons born or naturalized in the United States. The word also appears both in the Due Process and Equal Protection Clause. Person is used in other places in the Constitution. In the listing of qualifications for representatives and senators, Apportionment Clause, Migration and Apportionment, blah, 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 blah. But in nearly all these instances, the use of the word is such that it has application only postnatally. You decided that. Well, I mean, yeah, I guess you have a point. The word is such that it has application only postnatally, as in it would take an adult to apply the Constitution in these cases. None indicates with any assurance that it has a possible prenatal application. All this together with our observation, that throughout the major portion of the 19th century, prevailing legal abortion practices were far freer than they are today, persuades us that the word person, as used in the 14th Amendment, does not include the unborn. This is in accord with the results reached in those few cases where the issue has been squarely presented. Indeed, our decision inferentially is to the same effect, for we there would not have indulged in statutory interpretation favorable to abortion in specified circumstances if the necessary consequence was the termination of life entitled to 14th Amendment protection. This conclusion, however, does not itself fully answer the contentions raised by Texas, and we pass on to other considerations. I've skipped on down to part 10, part 10, so that we can just read through this. I'm swiftly running out of time, and I want to get through the rest of the Blackmun opinion so that we can comment on what would happen if Roe were repealed. In view of all this, we do not agree that by adopting one theory of life, Texas may override the rights of the pregnant woman that are at stake. So I think that this comes from the supremacy clause of the 14th Amendment. I really want to do a whole video just dedicated to that clause, because from the supremacy clause of the 14th Amendment, so much government growth and abuse of power has occurred. But suffice it to say that the federal government has or the Supreme Court in this case has decided that Texas doesn't get to define when life begins, because it's contrary to what the federal government wants to describe life beginning as. So let's move on. We repeat, however, that the state does have an important and legitimate interest in preserving and protecting the health of the pregnant woman, whether she be a resident of the state or a non-resident who seeks medical consultation and treatment there, and that it has still another important and legitimate interest in protecting the potentiality of human life. See, here's something interesting. So the Supreme Court, or I guess we should just really say Blackmun, concedes that the state has a legitimate interest in protecting the health of the pregnant woman and the potentiality of human life. But so Blackmun essentially says that Texas is allowed to protect both and not prioritize one over the other, because the Supreme Court is going to do that for Texas. And we're going to see that as we get into it, or as we get towards the end of this. But basically, in a federalism system, Texas could decide we would rather prioritize the potentiality of human life over the will of the mother, because we're not talking about the health of the pregnant woman at this point. We're talking about the will of the mother. We would like to prioritize the potentiality of human life over the freedom of the mother. And Blackmun says, no, you're not allowed to do that. You're allowed to prioritize the health of the pregnant woman or the potentiality of human life. If the potentiality of human life exists, then you may act to protect it. If it doesn't, then you must defer to the will of the woman. And then you may act to protect the health of the pregnant woman. And that comes in as far as regulating how abortion is to take place. It like setting health standards for how an abortion shall proceed. These interests are separate and distinct unless the potentiality of human life is desired by the pregnant woman. Then they're not. Because if the woman wants to be pregnant, then her health is just as important as the health of the unborn child. Because if the woman is not healthy, then the unborn child cannot be healthy. And the woman wants the unborn child to be just as healthy as she is. So they're not exactly separate and distinct. Each grows in substantially as the woman approaches term, and at a point during pregnancy, each becomes compelling. Basically, this is just an assertion. There is no legal standing to make this assertion. It's just an assertion that Blackmun wants to make. With respect to the state's important and legitimate interest in the health of the mother, the compelling point in the light of present medical knowledge. Okay, so we should make determinations on abortion based on present medical knowledge. That's the precedent that Blackmun has set with Roe versus Wade. The compelling point, which is where the health of the unborn or the potentiality of human life overrides the will of the mother. We've substituted health of the mother for will of the mother, just FYI, because at the earliest point in the pregnancy, you must perform an abortion, so you must regulate abortion for the sake of the health of the mother, is basically the way that this is going. And the compelling point is based on present medical knowledge. So as medical knowledge advances, present medical knowledge is going to change. Therefore, the compelling point is going to move. It's going to move around. Naturally, it's going to move to earlier in the pregnancy, because doctors and hospitals are getting better at keeping premature born babies alive. Is it approximately the end of the first trimester? Okay, so at the time of the passage of this, at the time of Roe versus Wade, it was at the end of the first trimester. Today, my understanding is it's much different. My understanding is that a baby born prematurely in New York is viable for the majority of the pregnancy, is my understanding. I might have that wrong, but Blackmun picks an arbitrary point of when the compelling point is. He just decided this is where there's the maximum or the minimum potential for human life, such that the state can intervene on behalf of the unborn child. And it's, as I said in a video that I did earlier, talking about the right to life, that nature is not arbitrary. Nature has set a definitive point for when life is distinct and unique from the carrier of life, if you will. Trimesters are of course, it's division in threes of the pregnancy. But we don't have to have trimesters. We could have semesters, and we could measure the development of a baby by semesters, which would be twos. You would have the first half and the second half of the pregnancy. And Blackman could have said, at the end of the first semester is when the compelling point is. Or we could have quartermesters. I don't know if that's the right way to say it, but that's the way I'm going to say it. We could have quartermesters. We could measure the development of the baby by quarters. And Blackman could have said the compelling point is at the end of the third quarter. This is arbitrary because of the way that we have decided, roughly based on the development of the unborn child, but somewhat arbitrarily. This is just what we've decided we're going to measure fetal development. So does Blackman have much legal standing? He has no legal standing. Does he have much medical or moral standing? I mean, he has apparently enough to make an arbitrary decision, and that's about it. This is so because of the now established medical fact, referred to above at 149, that until the end of the first trimester, mortality in abortion may be less than mortality in normal childbirth. That's an interesting case to make. So, infants born during the first trimester, prematurely born during the first trimester, have an abortion rate, or have a mortality rate that is higher than the mortality rate of abortion, which seems strange to me because the mortality rate of abortion, I'm pretty sure, is 100%. So how I can't understand. I can't understand what I'm reading. I can't. It follows that from and after this point, a state may regulate the abortion procedure to the extent that the regulation reasonably relates to the preservation and protection of maternal health. So you're still not allowed to take the health of the unborn child into account. You must allow the abortion to proceed during the second trimester. You just must make sure that the mother will be healthy afterwards. Examples of permissible state regulation in this area are requirements as to the qualifications of the person who is to perform the abortion, the licensure, the facility, the licensing of the facility. So you must be able to procure an abortion, but the state can regulate who may allow the abortion. So according to Blackman's standard, Joe Schmuck can perform an abortion during the first trimester because the woman's will is the overriding factor. The second trimester, then the state can say you have to have an abortion procured at these premises, but the state must still allow abortions to be procured. This means, on the other hand, that for the period of pregnancy prior to this quote-unquote compelling point, the attending physician in consultant with his patient is free to determine without any regulation by the state that in his medical judgment the patient's pregnancy should be terminated. So the only way that the state can stop an abortion in the second trimester, according to Roe versus Wade, is if the mother will die in the process of the abortion. There is no consideration for potentiality of life until the third trimester because Blackman says so. With respect to the state's important and legitimate interest in potential life, the compelling point is at viability, an even more arbitrary point than the trimesters. This is so because the fetus then presumably has the capability of meaningful life outside the mother's womb. As I stated earlier, viability is moving forward in the pregnancy. So, according to Roe versus Wade, theoretically, say we get to the point where a fetus is viable from inception, then the state can say, no more abortion. If you want an abortion, we're going to take your baby. You're not getting an abortion. This is so because the fetus then presumably has the capability. And sentence break here. Would the feminazis be happy with that? No, because the state's not going to pay for that thing. The state's going to say, you're giving us a responsibility, you're going to have to pay for this. And the feminazis will lose their minds. This is so because the fetus then presumably has a capability of meaningful life outside the mother's womb. State regulation protective of fetal life after viability thus has both logical and biological justifications. If the state is interested in protecting fetal life after viability, it may go so far as to ban abortion during that period, except when it is necessary to preserve the life of the mother. So still, the life of the mother, it's a life overriding another life, which is kind of a sketchy gray area of the right to life. It's very difficult moral and ethical questions to ponder. Questions that we don't have time to ponder for this video. Measured against these standards, the standards that Blackmun has generated for the sake of this case, Article 1196 of the Texas Penal Code, in restricting legal abortions to those procured or attempted by medical advice for the purpose of saving the life of the mother, sweeps too broadly. The statute makes no distinction between abortions performed early in the pregnancy and those performed later. Remember, these standards as Blackmun has laid out, are not spelled out in the Constitution. He made them up for the sake of giving the right to an abortion to women. This is not in the Constitution. This is, by definition, judicial activism. And a question, because Tomi Lahren has been running her mouth, is it judicial activism to erase judicial activism? Thought to ponder. Let's move on to Section 11. To summarize and repeat, 1. A state criminal abortion statute of the current Texas type that accepts from criminality only a life-saving procedure on behalf of the mother without regard to pregnancy stage and without recognition of the other interests involved is violative of the Due Process Clause of the 14th Amendment. Based on the standards that Blackmun has generated, it is not in the Constitution. You do not have a right to an abortion. Therefore, you do not have the right to get one in private. As I said earlier in this video, maybe it's probably in the previous hour, you only have a right to do something in private that you have a right to do in public. You have a right to speak freely, therefore you have a right to do so in private. There is no general right to privacy in the Constitution. For the stage prior to approximately the end of the first trimester, the abortion decision and its effectuation must be left to the medical judgment of the pregnant woman's attending physician. We just read this stuff. This is Blackmun legislating from the bench. Section 11 should be a piece of legislation, should be a constitutional amendment. This has no business coming from the bench. Let's skip on down. What is this paragraph? Because we just read all of this, so I'm going to kind of skip it. This holding, we feel, is consistent with the relative weights of the respective interests involved, with the lessons and examples of medical and legal history, with the lenity of the common law, and with the demands of the profound problems of the present day. Nowhere does Blackmun reference the Constitution, the governing document of the United States of America, the governing document of the court that Blackmun sits on. Nowhere does he reference the Constitution in justifying this holding. He references it here after he's obliterated the Constitution here. The decision leaves the state free to place increasing restrictions on abortion as the period of pregnancy lengthens, so long as those restrictions are tailored to the recognized state interests. The decision vindicates the right of the physician to administer medical treatment according to his professional judgment up to the points where important. State interests provide compelling justifications for intervention. Up to those points, the abortion decision in all its aspects is inherently and primarily a medical decision, and basic responsibility for it must rest with the physician. If an individual practitioner abuses the privilege of exercising proper medical judgment, the usual remedies, judicial and interprofessional, are available. Our conclusion that Article 1196 is unconstitutional means, of course, that the Texas abortion statutes as a unit must fall. The exception of Article 1196 cannot be struck down separately, for then the state would be left with a statute prescribing all abortion procedures, no matter how medically urgent the case. Although the district court granted appellate row declaratory relief, it stopped short of issuing an injunction against enforcement of the Texas statutes. The court has recognized that different considerations enter into a federal court's decision to declaratory relief on one hand and injunctive relief on the other. We find it unnecessary to decide whether the district court erred in withholding the decision. Footnotes. Footnotes for days. And the next section, the next big section is the concurring opinion by Justice Stewart and the dissenting opinion by Justice Rehnquist. And the dissenting opinion is quite lengthy in and of itself. So I don't think I'm going to take the time to read through it this time. I'm already beyond the second hour that I promised for Roe versus Wade. There's probably a lot of stuff in Rehnquist's opinion about the Constitution, about legal precedent, about different kinds of things. If you want to see us get into Rehnquist's dissent, let me know in the comments of this video or the prior one. That's going to do it for this series. Thank you so much for watching. Make sure that you come back for the impact of repealing or overturning Roe versus Wade. That's going to be the next video. There'll be a link to it in the end card if you're watching this on Saturday. So thanks. Come back next time.